First of our speakers is Dr. Nina Boeger, who is Reader in Law at the University of Bristol. She specialises in sustainability, in corporate governance and in social enterprise governance. And it's going to be Nina that's going to give the initial presentation. But also with us is another of the co-authors of this report, and that is Dr. Roseanne Russell, who is Senior Lecturer in Law, also at the University of Bristol, and she specialises in company law, corporate governance, and is Director of the Centre for Law and Enterprise at Bristol. So welcome to her. And then finally, the third author of the report is Professor Charlotte Villiers, who is Professor of Company Law and Corporate Governance at the University of Bristol. And she is an expert in company law, corporate governance, and has written widely on corporate governance. So those are the three authors of our report. And so Nina, why don't I turn to you to describe what your findings and what your arguments were in this report.
Thanks so much, Roger, and welcome everyone. I was mentioning to Roger and to Charlotte and Roseanne before that, you know, we are competing today with the hot phase of the Brexit talks. So I feel a deep gratitude that you've taken time out of the thriller, as it were, and joined us today. Thanks for joining. The report that we produced is very broad-ranging, and you're welcome to have a look at it. It's available online, and describes the relationship between sustainability as an ever important concept in today's world, and what companies can do, and the role of shareholders, and finally the legal and governance framework in the UK. Picking a theme out of that report isn't easy. So what I'm going to do in 15 minutes is the following. I'm going to share my screen with you now. And let me just do that now. And take you through it. I want to talk a few minutes about the concept of sustainability. As academics, we talk a lot about this. I want to make it. I want to give you one idea of sustainability that underlies our report, and I'd be interested to hear what you, as business people, think about those sort of ideas, because they are quite academic in a way as a background. I want to then focus on the sustainable boardroom. In other words, sustainability decision making in the boardroom specifically. What is the role of the directors here, and what are the challenges that they face? And then I want to leave you with a message that law has its problems, company law has its problems in this field, namely vagueness and all sorts of things, but we can use it as a launch pad for introducing greater sustainability within our companies. So let me see if I can convey this. Starting point here on, definitions of sustainability carry a great deal of complexity these days, not least because there are many of them. For us, there are three starting points, really. The first comes from natural science, and that's the finding that we've hit an ecological ceiling, that we've hit the limits of our planetary boundaries quite substantially, and we're facing an emergency on many levels in environmental terms. The second starting point comes from social science, that the environmental emergencies link in with social externalities and us hitting the social limits of our societies and our social ambitions that we're facing. And the third really goes to economics. And in particular to new economic theory that picks up on these two boundaries, if you want, or these limits that we've hit, and ask this: economics is about prosperity, and we're clearly not doing so well in prosperity if we're hitting social boundaries in terms of equality, in terms of social rights, and if we're hitting ecological boundaries. So what should an economy look like that provides prosperity within these boundaries? Now, the traditional trajectory of economics, of course, is growth. We've got a shift now from traditional growth to sustainable growth, ideas that pursue growth but through innovation, decoupling growth from social externalities. But new economic thinking takes this slightly further and argues that really we need to rethink growth a little bit more fully and see it perhaps not as an objective, as an overall economic objective, but more as an instrument that ensures us to achieve, or that helps us in one way to achieve our overall objective of operating in a safe and just space for humanity. Now, the best description of this concept of what I think is effectively a concept of sustainability and overall vision of sustainability really comes from Kate Raworth, and she calls it getting into the donut. And if we think of the social foundation as a floor, as the hole in the donut, as it were, below which we cannot fall, and we think of the ecological ceiling as the outer rim of the donut, and the planetary boundaries beyond which we cannot go, then really our sweet spot, our safe and just space for humanity is the donut. And that's our starting point really for looking at sustainability in corporate governance. Why? Because of course, what we're seeing is that business is a key actor in this. We cannot reach that spot without business playing along. Business, we need to react to these new economic messages, to the vision of sustainability that centers around a donut. But we also need them to be actors in shaping these messages. So the way that we see it in the report is really as a feedback loop, where on the one hand, the economics inputs and percolates through to companies taking some of these messages on board. But then on the other hand, there is an interaction going on where companies actively feed back and adjust their behavior and innovate and strategize, as it were, to make these messages the new norm. So what do we need? We need businesses and corporations and companies of all sizes to act as mini donuts. Where does it start then? And that's when we get really to the second part of what I want to introduce to you here, the sustainable boardroom. It starts with sustainable decision-making at management level. And of course, management feels often under pressure to maximize profits, but often directors and high-level managers or anyone making leadership decisions in a company also really want to leave a legacy of sustainability in the business. This is inevitably complex. And I want to introduce this to you, and I'm really interested to hear, because you're obviously closer at these decision-making processes than I ever can as an academic, but I think conceptually and sort of practically as well, I want to introduce this as two types of decisions that we're facing, or two types of, I guess, scenarios. The first you might call an easy case. And this is the case where you're looking for win-win, and most importantly, you're finding win-win. In other words, there is a good business case in certain decisions for pursuing sustainability and long-term thinking in the company. In other words, there's a good financial case for getting into the donut because you've got quantifiable financial benefits, such as, for instance, on the reputation, impact on the reputation of the company or motivation of workers. I call these the easy cases because, of course, then what you're doing is you're making smart profit. It's great. It's not easy to find, of course, but once you've found that sweet spot, you really are in the sweet spot, so pursue it. And then there are the hard cases, and these can arise, I think, and please, chip in the Q&A if there is other aspects here. The hard cases can arise because there is impact on on the company, but also impact in terms of sustainability that we simply cannot quantify. It's complex to measure, A, what impact the company has on the environment and society. Not all of this can be financially quantified. And B, what impact the pursuit of sustainability initiatives or not doing certain things really has on the company. So that's one aspect. The other aspect, I think, is that there are, of course, different sustainabilities in the sense that there are different stakeholders at play here. Sometimes something is good for workers that you decide to put a lot of energy in, but it's less good for the environment. It's less good for local communities. So there is always a balancing act in terms of stakeholder governance going on. And, you know, again, it's you who will have the experience on the ground of this much more than I ever can. And then, of course, the final aspect of the hard case is the fact that sometimes there just isn't win-win. Sometimes you either pursue sustainability and it hurts investors in the short and long term, and you have to decide whether to do it or not. The reason I've got the picture here of this lovely building is because this morning I was looking for a case study, and I don't want to go into much detail, but I think something perhaps for you to read up on once Brexit is done and dusted, and all the talks are over, and you're looking for something to look into. This is the new building that Google is building near King's Cross. And it's a fascinating, beautiful building. And if you live near King's Cross, as I do, then you will see that it's regenerated the whole area and so on and so forth. It's also really advertised. Well, it's part of the whole regeneration. It's not finished though, it's not full yet. It's also a project that Google has invested huge amounts in terms of sustainability. It's a very green building, as is pretty obvious from the picture. It's got all sorts of perks for its workforce, and it's trying to be inclusive in terms of regenerating the area and the local community. So it's doing a lot of good things, I think. And of course, by doing that, it's also really giving the Google brand a good boost for all the right reasons, perhaps. But there are some hard aspects to these decisions, and I just want to, you know, and to the Google project, I think, and as I say, I'm not deeply involved in this, but I can see just some things from reading around what's happening at King's Cross at the moment, that some of these issues around sustainability are very, very complex. Why? Because the impact on the local community, on someone like Google being in a beautiful but still very dominant building and in a very dominant position in that area, can be highly challenging. For instance, just a few questions here. Do people arrive by car? Well, near King's Cross, they probably arrive by train, but you know, you need to see what environmental impact is generated. Does it create an amount of exclusion towards local communities? Does it impact on local housing and property prices? Is the local area becoming too dependent on this kind of project? Because what we're seeing, of course, at the moment, currently in the COVID context, this is lying really empty. So everyone who's surrounding it, so let me put it this way, it's exposing a dependency and potentially a lack of sustainability in local communities through these extraordinary times. These are costs and potential externalities. There's not necessarily a business case here for Google to pick those up. And there's an argument whether Google should pick those things up, of course. The fact is, because this is not, you know, these are things that don't necessarily affect Google's reputation overall. And the question is, of course, should Google pick this up as an example, and should Google feel responsible for it? So I'm just hoping to illustrate these the difference in and the complexity of some of these decisions, really. And I think there are three ways in which boardrooms tend to resolve these three broad approaches. And I'm not sure I'm telling you much new, but let me just run through them. The first is really to focus on those what I call the easy cases, but whereas of course they're not always easy, but to focus on the business case and to look at financial calculations and clear financial impact, which of course from an accountability perspective is positive in the sense that you've got a very clear, reasonably clear objective to run by. The challenge is that it can be narrow, as I've just tried to illustrate, that there are aspects of balancing between sustainability and cost here that are more nuanced, and not all of those are caught by the business case. And then we of course have Pandora's box of greenwashing that feeds into, or the risk of greenwashing that can ensue, because if you focus narrowly on financial aspects and quantifiable aspects and the business case, arguably the risk of greenwashing rises. So that's one pursuit and one approach. The other two approaches really, in a way, go hand in hand. So let me just outline the purpose approach. The purpose approach really tries to go broader. It's really trying to capture some of the cases where there is no certainty that pursuit of sustainability will really increase profit, but there is a likelihood that it will, and there is a sense that it will increase the value, which is the purpose of the company, the value, the overall value that the company is producing for society. In effect, that approach in defining value more or less, and I'm talking about corporations that decide to certify as B Corps, for instance, that try to define a purpose and value, a value commitment in that way. That approach really tries to commit to a triple bottom line. So to pursue sustainable value by A, generating profit, which is key, whilst at the same time pursuing societal interests and social ambitions, and also paying high regard to the environment. And here you've got a little bit more flexibility to look at some of the hard cases, arguably. This goes hand in hand with a governance approach, and Charlotte Villiers is really the go-to person on this, so I'm not going to say too much on this because I'm sure she will pick this up, but a governance approach that builds values in the decision-making processes. And one really important value that we see is the value of compassion, and the changes in, if you want, the procedural aspects of governance, moving beyond a competitive environment towards a more compassionate environment, changing the input in order to change what pops out at the end in terms of the decision, in order to change the output. So the two go hand in hand to some extent, and so as I said before, there is a little bit more flexibility, arguably, in those approaches, but of course they're not without problems in the slightest, and this is where the challenges really lie here, and I imagine that some of you will have experienced these challenges or thought about these challenges, or really just dreamt about them, I don't know. So the first challenge really is about how do we account for purpose and how do we account for value. So there's a whole practical issue around accounting and reporting and accountability, because of course financial and quantifiable aspects are always a lot harder and easier, a lot harder and faster to account for, and easier therefore. Secondly, do we find investors that are attracted by these things? The whole idea of sustainable investment, slow money, etc., etc. So it opens up a whole field here in terms of matching investment and corporation. But thirdly, the one that I want to highlight here is the risk of mission drift, and that is the idea that, which I'm sure you will have you will have come across in one way or another, the tendency to really fall back into old habits. Even if we subscribe to a triple bottom line, even if we build purpose into our business and governance mechanisms that are inclusive, in the end, at the end of the day, it's hard to get rid of old habits that prioritize investment, short-term profit, and take aside and sideline sustainability, and especially the hard cases, potentially at least. So from a lawyer's point of view, then the question is, can we engage company law and corporate governance to help with these difficulties? And in order to have a look at these questions, really, it's necessary to A, look at the law as it is, and then B, and this is really where lawyers are getting quite excited at the moment, you know, what might we do creatively within the law, but also how can we take it further? How can we change it? So to start with the first question, how high is the bar currently for directors in pursuing the easy and the hard cases, i.e. pursuit of the business case and pursuit of further reaching concerns such as purpose. Now, the starting point, and I am sure that a lot of you will be familiar with this provision, the starting point I want to highlight here to you, just because it is so central, is section 172 of the Companies Act 2006, the section that sets out enlightened shareholder value. And as many of you will know, there are two elements to this. Overall, let me say, first of all, the section imposes a duty on directors in their decision-making, be it for sustainability or be it for anything, to act in good faith, to pursue what they believe is in the best interest of the company. Two elements then to that duty. First of all, what is in the best interest of the company really is to promote the success of the company for the benefit of its members, i.e. its shareholders. So this bakes shareholder value into the law really. But the second element then enshrines the enlightened pursuit of shareholder value and the idea that really we should encourage sensible and long-term decision-making in the pursuit of shareholder value, by specifying that in doing so, directors must have regard to certain key stakeholder interests and the long term. And those key stakeholder interests include employees, they include consumers and suppliers, they include relationships with communities, and the environment and the long-term reputation of the company and so on. So what this provision really does is it sets out a compromise between what we know as the shareholder vision of the company, and it then provides a nod to also what we think of as the stakeholder vision of the company involving stakeholders. There's no mention of sustainability here, but of course, considering stakeholders means effectively looking after staying in the donut, and that's why it's relevant in a sustainability context, this provision. So in short, it sets out a floor for directors where they have to at least nod to stakeholders. They must at least consider them. That's the floor. And it sets out a ceiling in that if they want to pursue sustainability and stakeholder interests that relate to sustainability, then they need to make sure that they have the investors, and i.e. the shareholders, at the heart of those decisions. So it's those two aspects, the ceiling and the floor, that are relevant here in the decision making. In practice then, there are a number of issues that I want to draw out to you, and this brings me really to a conclusion. I should take another 45 minutes, I should think. And there are really three practical issues that we are thinking about as lawyers, and that I think businesses are thinking about implicitly or explicitly when it comes to the pursuit of this duty and its floor and its ceiling. The first is the question of what does it mean to have regard, and what does it enshrine to have regard to sustainability and stakeholders? Two aspects to this. How do we do this? there's little guidance in the law of what concrete steps companies need to take and how to exercise this form of stakeholder governance. For bigger companies, we do now have a provision in 2018, since 2018, in the corporate governance framework that's tightened up, and a statement specifically on section 172 has to come in the report. But other than that, really, we're swimming a little bit here. And so we need a little bit more guidance, would be my view. The second point to make really is more substantive, in that the floor really is still quite low, because considering and having regard to stakeholders and by implication sustainability does not necessarily mean following through on those decisions. All you have to do in your decision making really and in your strategies is to show that you have consulted. That's a pretty low bar, I would argue, and others have as well. So there is no compulsion, as it were, to go any further in terms of output. That's the first issue. The second issue that I wanted to highlight to you is the definition of what it means to be acting in the benefit or for the benefit of the shareholders. And here, of course, you have potentially the other scenario where directors might want to go quite far in terms of pursuing sustainability and all sorts of stakeholder interests, and that includes environmental and social interests. And how far can they really go? And I think there are, again, I'd just like to highlight to you the two situations. Now, the business case scenario where directors clearly identify a benefit and a financial input, a financial impact that is positive for investors, is clearly captured here. And so in that regard, we haven't got an issue. The question is whether some of the harder and more complex cases are within the pursuit of section 172. In particular, those cases where stakeholder interests are either hard to quantify, or where it's really, as I said before, where there's a real sense that pursuing them runs counter and hurts financial investors in one way or another financially, whether that's in the long term or in the short term. The hard decisions, in other words. And here we have much less certainty. We have the question, can directors pursue this under Article 172? And I'd argue that potentially it might work if we take a broad view of what the members' interests and the benefit of the members are. But if we take a, let's say, a more orthodox position, then there really is a great deal of uncertainty around those what I would call the harder cases and the more complex decisions. And that then brings me to a final theme around section 172 and the duty to pursue enlightened shareholder value, and that's really, you know, what are the risks involved for directors in getting it wrong? And here I'm going to not say very much because Joanne Lowry is really the expert on enforcement here. So I'm sure she's gonna pick up some of these themes. But I do want to highlight two things. The first is that the enforcement, well, I guess the enforcement, just by way of information, works mainly judicially currently, and mainly through the shareholders, really. So question, to what extent are the shareholders prepared to pick up on issues of sustainability when it comes to asking and holding directors to account for decisions that should go further in terms of sustainability? That's the first aspect. The second aspect is that in those judicial proceedings, courts have traditionally very much deferred to the business judgment of directors and not intervened very much, or have put a high threshold on when they decided to intervene. That's of course good news in a way for directors, because it gives them flexibility and reassurance, and in some ways limits the risks of potential liabilities for getting it wrong under 172. On the other hand, of course, what we're also seeing is the law is just a little bit toothless when it comes to enforcing stakeholder interests, and it leaves little guidance. So just to conclude, the law does leave flexibility in terms of pursuit of sustainability and takes long-term encourages long-term decisions, but it's not ideally set up to do this. For directors who have strong sustainability ambitions, arguably there is not enough certainty. For those directors who don't or have no ambitions whatsoever, there is arguably not enough encouragement and potentially enforcement to create those ambitions. And that finally leaves me with this beautiful slide, and I'm not going to go through this in detail, but I did want to just outline this to you, because that then leaves us to consider really, how can we think about the law, given some of the, some of the promise in the law, but also some of the sense that there is room for improvement here and there is a great deal of uncertainty. How can we use law as a launch pad here, and what more can we do? And there are three areas here. Rethinking the scope of the obligation in 172, in the duty of enlightened shareholder, to pursue enlightened shareholder value. Some companies, as I said before, are doing this in their articles of associations, and they're actually changing away from enlightened shareholder value to a triple bottom line approach. But of course, we can think of whether this should be translated into a legal upgrade for 172 for the law itself. Secondly, then, there are issues of process. And this really goes to the point of making it clearer how directors can have regard to stakeholders and can commit to sustainability. For instance, introducing duties to produce forward-looking sustainability strategies, greater impact reporting, and introducing boardrooms to purpose statements. And finally, shifts around enforcement, which, as I said before, is just a tiny bit toothless right now. Can stakeholders enforce more? Are we finding ways for stakeholders to get involved here directly? What about the concept of business judgment? Do we need to have to think about introducing a firmer statutory regulatory structure into this area of the law? And what are the sanctions? And on that note, I hope I've been able to provide you with an overview of this area of the law, and I thank you very much. By the way, I chose this this picture just because I thought it gives you another sort of take on the donut. It's another ring on sustainability. This is a sustainable Advent wreath. Thank you very much.
Thank you, Nina. That's a festive take on sustainability, I think.
That's a festive take on sustainability, nice. Exactly.
Well, thank you so much.
You're welcome.
Now, I think what we will do is we will now move from Bristol up to Leeds, where we have Professor Joan Loughrey, who's waiting for us there. Joan, you're Professor of Law at Leeds, where you specialise in corporate governance and corporate law. I wonder if you might respond to what Nina has just been talking about.
Yes, I'm just going to pick up on one of the points that that Nina has been talking about, which does relate to enforcement. As Nina averted to the issue of enforcement or lack of enforceability of Section 172 because of issues relating to business judgment, which I'll explain what that is in a minute, is a two-edged sword. It's difficult to enforce Section 172. Because and that means that if directors want to pursue sustainability, they've got a large area of discretion to do that. If directors don't pursue this sustainability, and we want them to pursue sustainability, then it's difficult to use enforcement through Section 172 as a mechanism to do so. But first of all, I just want to say thank you to the Institute of Directors, and I want to thank Nina and Charlotte and Sam for giving me the opportunity to come and talk to you today. I mean, I thoroughly enjoyed the presentation. I thoroughly enjoyed the paper. And I think this is really, really topical because it's difficult to see that we can continue business as usual with the climate threat to climate and so forth. And we're in a position where, because of the pandemic, suddenly it becomes much easier, I think, to envisage what a global disaster will look like, and the need for all of us to engage and not leave it over there for someone else to think about. So it's a really, really timely paper, and I just want to say thank you for it and for the presentation and to the Institute of Directors. So I want to focus specifically on the proposal in the paper that not just shareholders should be able to enforce Section 172 and to get directors to think about sustainability. And that would be, in the paper, it suggests an amended 172, that Section 172 should be amended to require directors to think about the impact of their actions on future generations of stakeholders. The paper proposes not only shareholders should be able to enforce that, but also other stakeholders. And I want to talk about why that might be a difficult way of achieving sustainability gain. So, and decisions under Section 172 are what we lawyers would call business judgments, by which we mean they are commercial decisions. They are decisions that involve a high degree of uncertainty. They involve weighing different factors. They involve choosing between multiple courses of action. And basically, basically, the courts are very, very reluctant to second guess directors' business judgments, providing, under Section 172, providing that directors do actually take account of all the factors that are listed in Section 172 and any other relevant factors, then even though the ultimate decision they take could be egregiously damaging to the environment, then providing they can defend their actions and show how they reached that decision, that they took into account different factors in Section 172, the courts will be very, very reluctant to impose any liability upon directors for those decisions. And the reason is, as I say, because these decisions are considered to be business judgments, commercial decisions that the courts are very reluctant to second guess. And Nina has talked about the hard decisions. So when will the courts intervene? In an empirical study that I carried out with some colleagues a couple of years ago that was funded by the Arts and Humanities Research Council, we found that the courts were likely to intervene, but only in certain limited circumstances. And basically, you can put those under the umbrella of failures of process, failures in the process leading to a decision. So the most obvious one would be failing to take into account the factors that are listed in Section 172. But they also encompass things like failure to take advice on issues, for example, failure to take legal advice, failure to take advice from accountants and so forth. Where directors fail to inform themselves around salient issues. So they might have regarded them, but they haven't been properly advised in relation to the relevant factors. Other circumstances in which the courts have imposed liability is where they've taken advice and actually then they've simply relied too much on it. They've simply gone, oh, that person says we should do this, so we're going to do this, without actually really properly weighing it up. So undue reliance, and undue reliance also on perhaps another director within the company. Or where quite often challenges to directors' judgments come up whenever the company is actually insolvent. So the courts have also imposed liability where the directors have not been realistic in their assessments, where they closed their eyes to the obvious, where they've been recklessly blind optimism, what the courts have called blind optimism. Now, very occasionally, the courts will impose liability where a decision just seems unduly reckless and really colossally stupid. But even in most cases, in the vast majority of cases, there has been a failure of process, albeit that the courts may say something about the degree of risk being very high. In the course of this study, we did speak to judges and who hear these cases, and they said quite often when you get a director in front of them who can't explain why they reached the decision. It looks like a really weird decision that they've reached, a really rash, reckless decision, and they're asked why they did it. Quite often they can't actually explain, and the court smells a rat, and the court's more likely to impose liability in those circumstances. Judges are actually very pragmatic people. But then if you do follow the process and you do record and etc., then it's going to be difficult for the courts to find directors liable. So long as directors take proper advice and so forth. So what is the good of Section 172 if it's actually quite difficult to enforce? Well, as I said at the start, it protects directors' discretion for those who actually want to behave in a sustainable way. But it's also been argued that just making directors think about these different factors can change how they behave, can change the decisions that you make because you have regard to the factors, so your attention is brought to them, and that can change the output of your decisions. There is one problem with that, in that the research doesn't entirely bear this out. So there was a study done in 2011 and a more recent study done in 2019 by my colleague at Leeds, Professor Andrew Key and Taskin Iqbal. And they found that when Section 172 was introduced, and the previous study, it actually had a minimal impact on director behaviour. The 2011 study found that only 17% of directors said that they had changed their behaviour in response to Section 172. Now, that might have been because most of them were acting in accordance with Section 172 anyway, but clearly Section 172 was introduced to change behaviour. There was this idea that it would. So it has minimal impact in that direction. Now, why is this? Well, it might be because of the lack of enforceability of the section, and I've outlined some of the problems relating to business judgment. The other problem is that the cause of action, the way that the section would be challenged, would be through a legal proceeding called a derivative action, which allows shareholders at present to bring actions on the company's behalf where directors have breached Section 172. So the paper suggests that the ability to bring an action on this basis should be extended beyond shareholders, because shareholders may not be signed up to sustainability, and maybe it could be given to other groups, so for example, environmental groups. The problem here is that the courts tend to be fairly hostile, not just to challenges to business judgment, but also to the use of the derivative action. In order to bring such a claim, you have to get the court's permission, and the courts are very reluctant to grant permission because they're very, very wary of the disruption to the company's business. And even when there is some evidence that the directors have in fact breached duties, the courts have not always granted permission if they thought that to grant permission, if they think that the legal proceedings, the cure is worse than the disease, basically, than the illness. So again, there was a study carried out a while back that showed that between 2004 and 2006, of 27,000 claims filed against directors by shareholders, only one each year was against the director of a listed company, and only two since World War II have been have judgments been entered against listed companies. And again, more recent research bears out that against listed companies, certainly there's very few actions, but even against directors of private companies, in total, the number of claims brought per year under the derivative action against both public and private company directors are 2.7 per year. We're talking really small numbers. Why is this? Problems with shareholders are well aware that it's difficult to challenge directors in business judgment. Shareholders are well aware that the proceedings are very disruptive for companies and can impact on share price, and if you're a listed company, the cost of litigation, and also the attitude of the courts. So I'm pessimistic that presently, under the current structure, even if the people who can bring proceedings are widened, that it will make a significant difference. It gets around the reluctance of shareholders to litigate, but doesn't get around the reluctance of the courts to grant permission to these proceedings. So I think, and that's not to say I don't think these things shouldn't be done, because I think these things should be done, but we should need to be wary of, just how much litigation and enforcement will change things. So, and if we're looking to enforcement would be a last resort, I think. The answer here is likely to be through actions by a public regulator. A regulator will only take action when it is in the public interest to do so, which is the right thing, because it's a public body with public money. But this won't remove all problems, and the regulator is better able to bear the costs, but these kinds of proceedings are extremely costly. And this won't remove all problems. There still remains difficulties of how a regulator should decide what action to take in relation to decisions that are commercial decisions. And previous regulators are very wary of other regulators are very wary of taking action in relation to what are commercial decisions, where directors have been shown to think about things and then reach a decision that everyone then criticises. One example here relates to the financial crisis and the takeover of ABN AMRO by RBS, heavily criticised decision. The FSA didn't do anything about it. Why? Because it's a commercial decision that was in accordance with market practice at the time. Where regulators are more likely to take action is where the courts are also more likely to impose liability, where you fail to do something. So, for example, we think about the relatively recent fine imposed on the CEO of Barclays because he ignored a whistleblowing letter. He didn't do something. So regulators find it easier to take action under those circumstances rather than when there's a considered commercial decision that amounts to a business judgment. And then when they do take action, they get a lot of political flack. And also, it's costly. Experience from Australia shows that where they've got a very active regulator, that when proceedings are taken, if they're taken against companies, companies tend to settle. When they're taken against individuals, individuals fight because individuals care about their reputation. So there's cost issues as well. As I say, that's not to say I don't support these proposals. I do, but I think they're a last resort. And I think that there are other ways to do this. For example, if the directors in the room want to do sustainability, the difficulties enforcing Section 172 are good news. But there are other things that need to be done, and the paper does go into them, and that is the role of shareholders. Now, at this point, I'll just be quiet and open the floor to questions.
Thank you so much, Joan. Well, so there seems to be some skepticism about how the existing legal framework really encourages and nurtures sustainability. We've got a number of comments from people which I'll just relay to you, and I'll be particular. Maybe at this point we could bring in the other co-authors of the study, Charlotte Villiers and Roseanne Russell, maybe to answer a couple of these questions. I mean, one point that I do have to make, which is from Richard Smith, which is that if you want Section 172 to change director behaviour, surely one key way of doing that is through director education and through professional qualifications like chartered director, which tends to, my experience is tends to be overlooked. You know, there's almost a feeling you just pass a law and then leave it to the lawyers and the courts, and that will then change behaviour. But education also presumably should play a role. But maybe I could just also, Charlotte and Roseanne, will combine that with another question which has come from Stephen Page. I mean, he makes the point that a number of people, including Professor Alex Edmonds of London Business School, that they are arguing that if you pursue a purpose-driven approach, that is going to actually result in a strong business case being realised. It's going to generate profits. So actually, there isn't this trade-off between, on the one hand, pursuing the business case, or on the other hand, doing something, you know, should we say, which is good for society. What do you make of that argument?
Yeah, I think it's. Hi, yes, a great question, and I think it's a really strong argument. I think that the difficulties that we face, I guess, are timescales. So, for example, take the airline industry. They've been, you know, really badly hit through the COVID pandemic. They've also got huge, you know, everybody's looking at them because of the climate change problem. And I think they know that they face a huge challenge going forward. And so the question for them is to ask, how do we go towards like the zero carbon emissions economy? I mean, for them it must be a nightmare. And one of the things that they've got to do is to really invest in long-term research and development. And I think that for them, the issue that they have then is to persuade potential investors to fund these kinds of projects. And so you've got trade-offs in the shorter term, but then you've also got these long-term projects, which if you are investing in research and development, you don't know if you're actually going to come up with the goods. The whole point of it, it's research, it's development, it's exploration, it's experimentation, and some of that is going to go up dead ends. But we kind of have to go through that process in order to find the answers. And so I think that, there will be some really serious questions, asked, and there'll be different kinds of investors involved in that whole area. And it's not just airlines, there's, so many other areas that we can talk about. So, and that then also goes down towards the issue of purpose, corporate purpose. What is purpose? How long-term are we thinking? I mean, when we are in the arena of sustainability, I don't think we can just look at it as a 1-year thing, a 3-year thing, even a 10-year thing. I think we're looking at 30, 40, 50, even 100 years down the line, especially if we take the idea of sustainability and, making the world a safe place, not just for our generations, but for future generations. And I think that's where some of the really interesting discussions may well take place. And so this question that Stephen's asked around trade-offs is really interesting. Yeah. How do we measure these things over a long period of time? Yeah. And then on the point about education, I wholly agree with what Richard has said. I think that the chartered directors will be really useful here. And I know also the non-executive directors association, they are very into sort of developing qualifications for directors, and I think that's not necessarily a bad thing at all.
Yes, and I do think, as Richard says, I think we probably need to rethink within the Chartered Director qualification how we're incorporating these issues of sustainability, so that we're really embedding them in directors' behaviour.
Absolutely.
I also hear a question from Muir MacDonald, who asks, he's asking the question that, if you as a director, you really want to pursue sustainability, you want that to be a key part of what your organisation does, what legal form might you adopt to really embed that? Nina, I don't know if you might have some thoughts on that, because you've been very involved with B Corps, haven't you? And I mean, Muir MacDonald makes the point that, if you're like a John Lewis, that is owned by an employee-owned trust, ownership trust, that somehow could better embody sustainability issues. I wonder what your thoughts are.
Yes, thanks. Thanks. It's an excellent question, and it's it opens up a whole new perspective on this, which is not emphasized in my talk today, because it focused very much on the traditional company form. But effectively, very concretely speaking, you can look at purpose and build that into your articles. For instance, by becoming a B Corporation and choosing to certify yourself as such, and that requires you to fulfill certain legal requirements, effectively building the triple bottom line into your articles. There are, of course, always shortcomings in those sort of, I guess, innovative ways of looking at adjusting company forms. It can always be reversed, so you can never really exclude what I call mission drift in the presentation. B, it still relies on enforcement really through shareholders, but that can also be a positive thing. And I think this is what somebody else in the chat was really pointing out, that we have to rethink what shareholders and investors want here. So shareholders as stewards and coming in as sustainable investors are really interested in B Corps. So that's one route. But of course, then opening up the form of ownership of your company is a whole different route, and that's where you get into the area of employee trusts. Even the cooperative model is on the up, and quite fiercely on the up right now. So and that then links to new governance models. So it's new governance models and democratic governance models. So you've really got purpose, you've got ownership, and you've got governance, in my view. And those are the three things that you can adjust, and you've got menus for all three of those. So I'm happy to have a further reaching conversations on the on those.
Yes. Just one question I just would like to put from Irene Marie Esser, which is quite I think an important question, which is, if we're wanting to make companies more sustainable, are directors' duties, as in the Companies Act, directors' duties, is that the place actually really to encourage it, or is it maybe somewhere else in the law that would actually do a better job? I don't know if it is Charlotte or Roseanne might want to come in. Charlotte, yes.
Well, I agree with Irene. Directors' duties is certainly not the only place, and not necessarily even the central place, but they do play a very important role. But disclosure is obviously a starting point. I'm not saying that disclosure will take us all the way, but without disclosure, we can't engage and we can't hold to account. So disclosure really matters. And I know also that disclosure is very complicated. And I think one of the problems that we have with the whole area of disclosure is that there's a multitude of different disclosure rules and initiatives. And I think that must be very challenging for corporate directors. I think that really is a problem. But I also think that you can do some fairly not straightforward, but there are some things that can contribute to easing the path. So, for example, we might think about what committees we've got in our boardrooms. We've got our mainstream committees. We've got the nominations committee, the audit committee, the remuneration committee. But we might want to start thinking about which other committees could be really helpful in opening out the discussions, and who do we invite maybe into those committees. Is there a possibility for us to be a bit more imaginative here, that we could invite, other people to really advise, guide that boardroom in the right kind of direction? So there's sort of a couple of immediate thoughts. And then I also think that where we were talking about educating directors, I really think that there's a role here to educate the investors and the shareholders here, because I do think they have a very important role. I'm personally not a shareholder primacist in my way I write and think, but I obviously am very mindful of the hugely important role that shareholders have, and I think we should maybe be thinking about bringing them into the discussions in positive ways. And I'm also very much in favour of fair treatment of our employees and workers beyond the immediate company. So yeah. They're just a few thoughts from me.
Nina, would you like to have a final word on this, actually, as we come to the end?
I wanted to say that I couldn't agree more with what Charlotte was saying. I also want to highlight, though, why I do think there is a central role for directors' duties, because what you have in 172 and the whole duty framework really is, it kind of goes beyond directors' duty. It sets out the frame of what we understand the company to be there for. So that's why it becomes such a central starting point in terms of I guess, the future design of our companies, and that's where we can build some of the other discussions on. That would be my take on focusing on it.
Nina, thank you so much. And thank you so much also to all the other speakers, to Charlotte, to Joan, to Roseanne. Thank you all very much indeed. I encourage anyone who wants to read this paper further. There is a link to the complete paper, which is on the registration website, so that you can see it there. If anyone would like to see the slides that Nina presented today, I think Nina, you will have a version available in due course, which people could reach out to us to obtain. But the final thing for me is to say, on behalf of the IoD Centre for Corporate Governance, thank you very much, all of you, speakers and discussants, for this excellent paper. Thanks to the participants for your questions. And we very much look forward to seeing you at the next event of the IoD Centre for Corporate Governance. So thank you very much.